My paper discusses the Roman legal treatment of poisoning grounded on the Lex Cornelia de Sicaris et Veneficis through the methodological lens of imperial rhetoric in the form of forensic declamation. I will explore the possibility that the judicial and juristic interpretation of the Lex Cornelia developed in line with the construction of Veneficium in the schools of rhetoric. Under this premise, I shall argue that the normative extension of the Lex Cornelia to include the reckless administration of specific and potentially lethal substances, as attested in legal sources of the 3rd century CE, was based on an element of criminal liability that was debated already in the 1st century within the schools of rhetoric. Understanding how judicial debates structured around a charge of poisoning were likely to be conducted in Roman court practice can help us gain a more detailed view of the dynamic socio-ideological development of the Lex Cornelia and its interaction with contemporaneous medical knowledge on poisons during a time when the preparation and administration of venena for the purposes of homicide seemed to have reached an alarming peak, especially in the imperial court. First, I look at questions of method, the disputed definition of poisoning, and Roman medico-legal expertise. In the last section, which is the core of my paper, I analyze Pseudo-Quintilian's Declamatio Minor 350, which offers a distinctly unique fictitious legal case, for it discusses a suspicious death caused by drinking cold water. Let us switch to slide 2, please. The topic of Veneficium has recently gained increasing attention in the context of Latin imperial forensic declamations. Distinguished between controversiae and suasoriae, these texts are the mainstay of Roman rhetorical education from before Cicero to the very end of the empire. Forensic declamations provided parallels to real-life court practice in preparation for which they were originally designed. Modern scholarship has laid emphasis on these texts with a special focus on the legal understandings, wider cultural perceptions, and gender stereotypes characterizing the activity of using poisons. Although in line with previous analysis, my approach differs in that it shifts the focus towards the problems of interpretation that could presumably arise in real cases of Veneficium, in an attempt to highlight, though not exhaustively, the Roman equivalent of criminal investigations that would fall under the scope of what we today call forensic toxicology, or more generally, forensic pathology. As we shall see, the declamation under scrutiny is concerned with the identification of a cause of death, a causa mortis, which is less clearly identifiable for two main reasons. There were no technological means of retrospectively proving or disproving alleged poisoning at the turn of the 1st century CE, nor are there any sources of Roman classical law explicitly attesting to the legally mandatory use of physicians as expert witnesses in cases of suspected poisoning, which implies that the presence of potentially toxic substances in the human body would be difficult to detect, to explain, and to prove unless their use was inferred from their effects. This is not to slip into the logical fallacy of assuming what I will try to demonstrate, namely that the interpretation of the presence of potentially toxic substances in the human body, conducted with anticipation of the need to be defensible in a public court, seems to have been incumbent upon Roman law practitioners. But to add a new dimension to our research infrastructure, that is, the heuristic use of judicial argumentation patterns in problematizing questions of proof that were central to broader normative debates about health and legality. I will try to do so by examining how the inquisitive mind of the Roman law practitioner was trained to reason and to argue in cases of homicide, and how the rhetorical elaboration of the medical definition of poison, grounded on the cultural horizon of the Lex Cornelia de Sicaris et Veneficis, may have influenced its subsequent jurisprudential conceptualization. To that end, I adopt a new line of research that promotes the idea that forensic declamations can be understood as an interdisciplinary interstice between forensic rhetoric and Roman law, and that in the study of actual Roman legal practice, there is the need for a renewed hermeneutic operation that favors the historicization of strictly technical legal literature through the analysis of the implicit dialogue that Roman law developed with intellectually coherent disciplines at its time of production, such as medicine and rhetoric. Slide 3, please. The original text of the Lex Cornelia is lost, but it can be partially reconstructed from later citations and allusions in legal and literary sources. The law was originally enacted against assassins and poisoners. Under it were punished with equal severity not only those who committed homicide, but also those who did overt acts for that purpose and with criminal intent, which shows that the law did not deal so much with the result as with the intent. Thus, a person who prepared and gave poison to kill someone was as guilty as those who actually committed homicide. This interpretation of the law may now seem fairly straightforward, but this was certainly not the case in Roman court practice, for the term venena was formerly regarded as ambivalent enough to denote a wide range of substances, including licit ones that were used, for example, as love potions or somniferous drugs. The crimen venefici was committed by the administration of substances that were considered to belong to the sphere of magic and that could alter a person's health at a physical and cognitive level. The activity of using venena was criminalized and punished if the effects caused were deemed harmful or censurable from an ethical point of view. Thus, according to the jurist Marcianus, in the beginning of the 3rd century CE, the preparation and administration of a love potion, amatorium, was not considered to be a crime if there was no proof for the required criminal intent. But for Quintilian, 1st century CE, it was debatable whether the definition of a love potion could fall under the scope of the Lex Cornelia. Insofar as it can be accurately reconstructed, the 5th clause of the law criminalized the preparation, sale, and possession of venena for the purpose of homicide. Venenum is an oxymoron insofar as it denotes any substance which, when absorbed by the human organism, is capable of interacting with the body, both in the direction of restoring the functions of the organs affected by a disease and of causing death. A venenum malum has the negative connotation of poison. But the relationship between venena and medicamenta is disputed in legal terminology. It seems that venenum, perhaps a near synonym of medicamentum already in the 12 tables, was still understood in classical Roman law as a neutral term, a nomen medium, that could be used both in the sense of medicinal remedy prepared for the purpose of healing and noxious drug prepared for the purpose of killing. It also seems that the normative addition in the Lex Cornelia, presumably through a decree of the Senate, of the qualifying term malla, served to disambiguate the broad definition of venena. The jurisprudential conceptualization of venenum as a nomen medium coincides, although not perfectly, with evidence drawn from non-legal sources that prioritize the negative connotation of poison. While venenum was used in non-medical literature of the 1st century in the sense of poison, as opposed to medicamentum and remedium, which referred to antidote, contemporaneous specialized pharmacological literature offered a treatment of mala medicamenta as both poisons and venoms. More importantly, both legal and non-legal sources recognize the potential of substances to act as both remedy and poison, and also that the inherent ambiguity of the term venenum lies in dosage, that is, in its being bonum or malum. However, when taken in isolation, these attitudes do little to minimize the problem of the untranslatability of the term venenum, which is why I would like to raise 2 problems that are of direct relevance to the declamatory elaboration of beneficium. First, what was the ethical framework that determined the responsible use of venena in a society with neither formal medical schools nor licensing boards? And second, if the concocted potion must technically qualify as venenum malum for the Lex Cornelia to be applied, how could one determine the death of a person in a case of suspected poisoning due to reckless administration of ingested substances? In an attempt to give appropriate nuanced responses to these questions, and since our sources do not yield precise fixed definitions, I will use the term beneficium heuristically, and much like Roman declaimers, I will conceive of it as an open, debatable notion underlying a multifaceted social practice and cluster of moral concerns that compelled law practitioners to negotiate its meaning in relation to the interests that were at stake in a given case. As regards the second question, I will consider with Evelyn Höbenreich and Junior Rizzelli that the legal answer to how one could evaluate reckless administration of venena would most probably be a pragmatic one, only if there were lethal consequences or a serious deterioration in someone's health, which means that the prerequisite for criminal liability under the Lex Cornelia would be that the injury bore a direct, explicit, objective causal relationship to the agent's act, even if that act was not malicious. I believe that forensic declamations on Veneficium offer a proof of the synergy between law and forensic rhetoric in clarifying and updating the reception of the Lex Cornelia in and through court practice. And if we consider that the historical development of pharmacological knowledge about poisons and antidotes depended on the progress of medicine in understanding drug mechanisms, and that this progress had an indirect impact on what could legally constitute proof of poisoning, it is reasonable to infer that the primary point of contention in trials revolving around the charge of Veneficium would be the definition of venena and their legal qualification as mala. It is therefore against this inference that I shall examine Pseudo-Quintilian's Declamatio Minor 350 with a focus on the arguments used to define cold water, a nomen medium, a neutral substance, as poison, venenum malum. But before doing so, I would like to briefly discuss the limits of Roman medico-legal expertise in Imperial Rome. Slide 4, please. In principle, the possibility for professional physicians to receive some legal recognition and social legitimacy while presenting themselves as a science suitable to intervene in the management of deviance seems to have existed in Imperial Rome. There are numerous instances in Justinian's Digest regarding the forensic deployment of physicians in cases of a medical nature, such as contested paternity or a type of mental disorder that was deemed dangerous to the family or to the community. The problem with such instances is that in their formulation, there is no mention of direct consultation of contemporaneous physicians, which makes it difficult to assert whether the forensic role of physicians in Roman legal procedure was or not peripheral. Non-legal sources record similar instances. One cannot help but think of Suetonius's account of Julius Caesar's mortal wound in the opinion of the physician Antistius, or of the various historiographical accounts recounting Germanicus's suspicious death. In the former case, it is not specified whether medico-legal investigation was motivated by a judge's intention or prerogative or order, and whether consultation of the physician was common procedure in ascertaining the cause of death, while in the latter case, there is no mention of post-mortem examination or even of the need of medical testimony in such a high-profile case of suspected poisoning. Evidence from the Greek papyri of Roman Egypt suggests that a physician's examination and subsequent report were required in cases of violent or accidental injury or death. And since no equivalent procedure existed in Ptolemaic Egypt, it seems reasonable to attribute this practice to the influence of Roman law. But Greek papyri do not prove conclusively that a medical examination was legally mandatory in such cases. It may well be the exercise of the magistrate's prerogative. Greek papyri are more likely to prove that at least from the mid-2nd century CE, in the increasingly bureaucratic judicial system of Roman Egypt, there was a body of legally designated medical experts enjoying a recognized forensic status, the public physicians, the demosioi iatroi. These physicians, whose title remains unattested throughout the rest of the empire, were appointed by magistrates to conduct medical examinations in cases of violent or accidental injury or death. But it is important to note that also private individuals could request the magistrate to appoint a public physician employed in a forensic role by the state to conduct a medical examination as an impartial official. This differs considerably from privately requesting one's own physician to appear as a witness in court. This most probably unique practice in Roman Egypt has been regarded as not being consonant with the evidentiary principles of Roman law, which is founded on a theory of free weighing of proof. It is true that the Roman judge was expected to decide from his own conviction, ex sententia animi sui, But there is no system of evidentiary principles of Roman law, nor a legal theory of free weighing of proof. It is the rhetorical doctrine of proof, exemplified in Quintilian's Institutio Oratoria, Book 5, that determined judicial interpretation and adjudication. And this doctrine could accommodate witnesses, testes, in the modern sense of expert witnesses, insofar as official inspections and professional declarations, not only of a medical nature, were viewed as admissible evidence in criminal proceedings. This suggests, in my view, that the lack of legally designated groups of forensic experts outside of Roman Egypt was not necessarily a failure of the Roman administration, but symptomatic of a society in which law and medicine were distinct in the diagnostic ways in which they alleged causes in medico-legal investigations, intellectual versus empirical. Moreover, the fact that in the present state of sources, the expertise of physicians, assuming that it was construed as an impartial expert testimony, does not appear in Roman legal literature as a procedural matter, but only as a relevant option, suggests that physicians would be solicited at the pre-trial stage at the request of the judge in order for their testimony to be codified in the advocate's speech at the stage of the trial. This possibility, I argue, can be traced in forensic declamations, which offer a picture certainly not easy to read, but in any case indicative of the different disciplinary positions that the law practitioner took on the evaluation of a crime and a criminal during the judicial debate. It therefore seems important to analyze the rhetorical strategies that formed the basis of such technical judicial investigations. Let's move to slide 5, please, and let us begin with the theme of the declamation. A man had a son. When he lost the boy's mother, he married another wife. The son fell gravely ill. Doctors were called in. They said he would die if he drank cold water. The stepmother gave him cold water. The youth died. The stepmother is accused of poisoning by her husband. The accuser brings a charge of beneficium because he believes the case to fall within the scope of a fictitious law on homicide through poisoning. However, the theme of the declamation of this school exercise does not explicitly state the lex benefici that governs the case, as would have otherwise been expected, which anticipates the problem of the applicability of the law, of the appropriate legal norm. If the declaimer uses the lex Cornelia de Sicaris et Beneficis as his implicit point of reference to construct this lex benefici, what we have here is a case of private poisoning in the context of a fictitious public criminal trial, and the declamation supposes a fictitious law on homicide whose conceptual structure most probably refers to the lex Cornelia. The causal sequence of events as established by the theme is the following. A man whose wife has died remarried. His son from the first marriage fell gravely ill. The physicians diagnosed him as curable unless he drank cold water. His stepmother voluntarily gave him cold water, knowing that this would be fatal for him, as a result of which the young man died. The father is now laying a charge of beneficium against his second wife. The accusation will argue that in this case there is an intent to kill. The defense will object that there is no basis for a charge of beneficium because cold water is not, technically speaking, a poison. And if the strongest line of argument for the defense is that cold water is not a venenum malum, the accusation will have to argue that in this specific context, cold water had the effect of a venenum malum, and then employ a syllogism. Should the stepmother not be punished just as if she had killed her stepson with a venenum malum? If criminal intent is taken to be the crucial element in the definition of the disputed crimen benefici, as the accuser would have it, there will have to be arguments that analogically extend the spirit of the fictitious law to similar cases where a substance that functioned as venenum malum was the direct causa mortis. The crux of the controversy lies therefore in establishing the causa mortis of the sic stepson by determining whether the stepmother's alleged act should be punished as a voluntary beneficium, and hence whether the objective material causal link between the stepmother's conduct and the stepson's death should be linked to the subjective element of the crime, and the analysis of her conduct in volitional terms so as to determine the degree of her responsibility as willful or reckless. These elements represent two different sets of problems in the Roman jurisprudential conceptualization of homicide. On one hand, we have the causal nexus between the criminal act and the final result. On the other hand, we have criminal liability. It should therefore be remembered that even though the stepmother's act appears to be fundamentally malicious in the logical unfolding of events that led to the death of the sick stepson, it is one thing for the law practitioner to establish at the level of judicial argumentation that the stepmother's act directly and factually caused the death of the stepson, and a whole another thing to prove that implicit to this act was her motive to kill the stepson. The father's underlying reasoning is whether the cold water, which is not a malum venenum in itself, can be qualified in this case as such, and if yes, whether the causal link between the stepmother's willful misconduct and her stepson's death can be inferred from this effect. And although the stepmother will not say anything explicitly incriminating, the charge of beneficium is already an interpretation of the alleged act. What she did is, according to her accuser, to procure death through the use of a substance, a seemingly neutral substance that reveals, however, her criminal intent. Slide 6, please. With this context in mind, let us examine the father's speech, which, although given as a first-person account, delivers the stepmother's rationale in an oblique manner. We shall focus on the way in which Pseudo-Quintilian, speaking as the accuser, Pseudo-Quintilian, so the master of the classroom, of the rhetorical classroom, speaking as the accuser, tackles two major issues: the applicability of the law to the case at hand, and the legal qualification of cold water as poison. The speech begins as follows, paragraphs 1 and 2. The accuser, I will read the text, I'm sorry. This is a poisoning charge. I shall have no trouble proving that my son died, and died of the drink that his stepmother gave him, for she does not deny that she gave him the drink and that it was dangerous, the warnings show. She cannot even offer ignorance as a defense. What happened was predicted. So she does not rely so much on a defense as on the law. And she can so well say that she did not commit the crime as that she committed it with impunity. For she says that she can't be liable for poisoning since she did not give him poison. The accuser begins by establishing that this is not a conjectural case. We are not asking whether poisoning did actually occur. Indeed, the accused does not deny that she administered the draught to her sick stepson, knowing its dangerous effects as the physicians warned against them. However, the term used for draught is ambiguous. Potio can either mean a potion given as medicine or a motiferous draught, Since the instance of suspicion is offered by the element of cold water, the point of contention is whether what transpired is in fact an act of poisoning, and more specifically, whether a neutral substance like cold water can be qualified as poison. In an effort to anticipate the subtle distinction between causing death and wanting to cause death, the accuser asserts that he has no difficulty in proving the direct causal relationship between the death of his sick son and the action that caused his death. For it is clear that the stepmother cannot develop a line of defense on the grounds that she ignored the factual circumstance that the cold water would have had a harmful effect in this context. And since this vital information has been made available in advance by the physicians, she was well aware of the dangerousness of her act. The terms praedicta and ignorantia are strategically used in this regard. Denuntiatum also is an interesting lexical choice. Quintilian employs the same term to refer to the witnesses whose presence in the public court was demanded by law. As a result, claims the accuser, the stepmother relies more on the text of the law and less on the articulation of a defense. She cannot deny that she did not commit a crime, so she objects that she committed it with impunity, which is to say that her act was not criminal in itself, or better yet, that she does not deserve punishment because she did not commit the act corresponding to that described by the law. The stepmother goes so far as to abdicate her potential responsibility by contending that she did nothing illegal. Her thesis supposes that the fictional law is indeterminate in the sense that it does not describe in clear and precise terms the limits of poisoning. Consequently, she denies being liable for poisoning because, in her view, the concrete case at hand cannot be subsumed under the abstract case provided for by the law because the law does not specifically mention cold water as poison. In this way, the stepmother pleads non-existence of the alleged crime due to a total lack of the objective causal element that would constitute a criminal act of beneficium. Without a poison, there can be no sufficiently direct and strict causal nexus between her action and the death of the sick stepson. However, this is the stepmother's point of view through the prism of the father's speech, which explains the use of venenum and not of venenum malum. It is in the father's interest to maintain the ambiguity surrounding cold water at this level of the judicial argumentation. Slide 7, please. If the judge accepts that administering cold water cannot be regarded in this case as an act of poisoning, and hence that the stepmother has not committed the crime with which she is charged, the accuser will be thought of as having brought a false accusation. In order to anticipate and rebut this implicit presumption, the accuser raises the issue of the applicability of the law. Before addressing the questions pertaining to the definition of poison and whether what was given to the sick son at that particular time was a noxious substance, the accuser entertains the hypothesis that there is no law punishing poisoning by cold water to determine what similar law would have to be applied to the present case. Since he cannot stand on the wording of a specific law, he needs to make the case fall under the intention of another similar law. By alluding to the quintilianic doctrine of syllogism, the accuser raises, as already mentioned, the problem of analogical interpretation in Roman criminal law. To corroborate the idea that the disputed beneficium falls under the scope of a fictitious law on homicide, the father makes a comparison with civil procedure. Supposing that the success of a plaintiff's claim depends on the suitability of the submitted facts to the legal formula under which the action is brought, it is not uncommon that in civil trials of this sort, says the father, a plaintiff fails to present a correct statement of claim, and since the allegation on which the claim is based appears unfounded, the claim is not actionable. In such a case, the plaintiff could be thought of as having brought an ill-considered claim, which raises the question for the law practitioner, not the jurist, as to whether he should be allowed to plead at all. The underlying idea seems to be that a word error in the legal formula could be tolerated, but an act causing the death of another human being is not an error because it is calculated. One should not believe that Pseudo-Quintilian ignored the fact that no error in the legal formula could be tolerated in actual Roman civil procedure. With this argument attributed to the father, Pseudo-Quintilian uses this antithesis ironically to highlight the absurdity of the idea that a homicide could be excused on the pretext of a false accusation when no other law can moreover be invoked to punish the culprit. Overall, the comparison with Roman civil procedure, as established by the father, is functional in rhetorical terms of intensity. If this was the situation in trials of not public importance, in a criminal trial for homicide through poisoning, it would be unimaginable that the accuser brings an incorrect charge. Consequently, the possibility of malicious prosecution would be conceivable, according to the father, only if a more appropriate law could be applied to the case at hand. However, he says, the advocate of the stepmother, who neither admits the actio benefici nor invokes another law, merely states that what his client did was lawful, even though it was a scelus, a crime. In response, the accuser argues that although there is no specific law punishing poisoning by cold water in these exact terms, it is customary from a procedural point of view, consuetudo judiciorum, says the father, that in lack of a specific legal action, the judge applies by analogy to the case at hand a similar action. The accuser insists on the problem of analogical reasoning in an effort to narrow down the definition of the disputed beneficium. The impossibility of covering every kind of criminal act, omne genus nequitiae, led to drawing up legislation as abstract as possible, but also through specific individual classes of crimes, per genera singula, which by inference could be interpreted analogically. What we have here is a feature of class logic whose division by genus and differentiae supports similarity decisions. Quintilian teaches us that this kind of division is heuristic in nature, as it accommodates judgments of plausibility in borderline cases. For instance, says the accuser, homicide is applicable to cases involving blood and weapons, that is, violent corporeal acts and armed agents. However, it may also cover, through analogical reasoning, other forms of killing, that is to say, not direct causes, but causes of causes, which enter in a chain of causality that leads to the death of a person. Through this allusion to the lex Cornelia, the accuser borrows the idea of a means or method of killing from which to infer criminal intent on the part of the stepmother. He thus implicitly establishes medico-legal causation. The only law that applies to this case is the one on poisoning, because the substance used for the purposes of homicide, albeit neutral, had the effect of a poison, which implies that the stepmother's act constitutes a singularly necessary element for causing the death of her ill stepson. Slide 8, please. The accuser now moves to the second question, which is the definition of venenum and whether cold water can be classified as a venenum malum. Even if the accuser concedes that this is not a beneficium, the question, how can one define cold water in this case, still remains open. And since the only possible answer is an ingested substance that caused death, the accuser claims that it is indifferent whether cold water is or not an ordinary cause of poisoning. What matters is that in this case, this neutral substance had the effect of a poison. This is corroborated by arguments on the nature and effects of various venena. Here we have a scientia of venena that ultimately fall under the scope of the same law on beneficium and that show awareness of specialized pharmacological knowledge regarding the classification and effects of poisons and venoms. What is interesting here is that according to the accuser, the father, venena, just as remedia, can have both healing and lethal effects depending on the organism that consumes them. Once again, the accuser links to the precondition of his son's illness the circumstantia of time. Differentia temporis, in paragraph 8, recalls ab illo tempore in paragraph 3 and proves that the cold water may well not be a poison in itself, but it functioned as one considering the son's ill health. Through the contextualizing question of time, the interpretation of venenum is thus framed in such a way as to show that the stepmother knew that in this specific context, the cold water would have a lethal effect, and she desired that particular effect. Her criminal intent, animus dantis, says the father, is proven by the physician's warnings and also by death itself. What more could have suffered his son, asks the father, if he had drunk poison? Whether she gave hemlock or water, physicians, judging from the poison's effect, would qualify it in this context as poison. If there is no death, because if there is no death, there is no poisoning either. Although the physician's diagnosis is narratively reduced to a minimum, the accuser uses it strategically to provide an instrumental explanation of the complex assessment of the circumstances of his son's homicide. It is this consideration of the chain of causes viewed objectively and of the stepmother's agency on the chain of causes that allows the law practitioner to legally qualify the stepmother's act as poisoning. Slide 9, please. It is now time to establish the culprit's animus. First, the accuser will have to ascertain that the stepmother was not in a situation that prevented her from being aware of her action. The subsequent verification that is required to determine criminal liability is of an objective nature, in that it is carried out precisely by measuring the conduct of the agent according to an abstract model of diligent and prudent behavior. In short, the question is whether the stepmother's action was willful or reckless. I'm reading the text. So much as to law, but to attach the defendant to her proper statute, here's the problem of the applicability of law. Let us by all means examine her intention too. I won't say who the giver is. Meanwhile, I reply that she gave cold water. Suppose the doctors didn't forbid, had no fears. It is enough that they didn't give permission. I don't stress the persona. I say nothing of the wording. You gave a sick person what his father would not have given. If just one of the doctors had said that the potion would only harm, I would say, in spite of all, perhaps you did not think he would die. You only wanted to harm. As it is, all the doctors agreed that he would die if he drank cold water. You have it after there was a certainty. I should like to know whether you did anything like that before his sickness. For if you did, it is plain how he was brought into such danger. If you did not, it is plain that there was a reason why you did it. And here is the mother speaking at the first person. I did not think it was harmful, and I did not believe the doctors. Are medical experiments so little known? The father says that he will not openly blame the stepmother. He says, I will not blame her who gave the poison, non dico quae sit, quae dederit. He simply objects that she gave cold water. Of course, the figure of irony does more to implicate the stepmother than to exonerate her. The father then appeals to the authority of the physicians. Supposing that they did not expressly forbid this course of action, it suffices to say that they did not permit it either. And even if the father does not openly accuse the stepmother and says nothing of the medical diagnosis, which is an irony because this is exactly what he does, the fact remains that the stepmother gave to her sick stepson something that his own father would not have given, thereby frustrating the healing process and the familial hierarchy. The implication is double. She did not consult with the father, as it would have normally been expected, and she acted at the expense of her stepson as if she had absolute control over his life and death. This questions the father's potestas and overall authority, while establishing an implicit analogy between the helpless stepson patient and the unscrupulous stepmother physician, who can turn a neutral substance into a mortiferous poison, a venenum into a venenum malum. The consensus in the physician's expert opinion bears closer inspection. From this, the father implies that it is impossible for the stepmother to say that in such controversial points where physicians are not in agreement about the lethal effects of cold water, the latter could function as medicine. To that, the father would have responded that by taking the risk of giving to the sick stepson an ambivalent draught, the stepmother need not be deliberately harmful. A simple error could have still caused some damage in the same direction. But as things stand, the physicians agreed unanimously that the sick stepson would die if he drank cold water, and the diagnosis is clear about that. By administering the draught in full knowledge of the facts, she transformed cold water into an instrument of death. This is proof of criminal intent. Her mind was directed towards a specific goal, and she did everything to achieve it. She intended poisoning, she foresaw the result, she desired its effect. Yet the father pushes the argument even further. If the stepmother used cold water as a chronic poison before the stepson was diagnosed with his illness, she is responsible for poisoning him slowly. The argument on the extent of toxicity shows awareness of the causal relationship between dosage and damage in ancient pharmacological thought, and implies use of arsenic, whose success was guaranteed by the administration of small continuous doses that produced a progressive state of prostration in the individual, which in the absence of toxicological investigation could be interpreted as the cause of a fatal disease. If the stepmother did act in that way, says the father, the crime is solved. If not, it is still proven, for it is clear, according to the father, that the cause of veneficium was deliberate and that the stepmother had a motive to kill her stepson. The declamation ends somewhat abruptly with the ethopoeia of the stepmother, who says that she did not think cold water would have been harmful and that she did not believe the physicians. The context where the declaimer innovates is the following. The misconduct imputed to the stepmother normally causes no harm, let alone death, but the physicians gave a scientific rule, so to speak, in the diagnosis that the stepmother did not follow, although she should have, because she knew of the risk and the fatal result that the prohibited administration of cold water was likely to have. Through her ethopoeia, not only does she display a manifest ignorance, but she also gives proof of recklessness by openly admitting that she did not abide by the scientific rule represented in the medical diagnosis. In comparison to the ideal behavior that a diligent and prudent person would have observed in the same situation, she is therefore at fault, culpa. Furthermore, she seems to pretend to be not only an expert enough to know that cold water cannot cause death when intended as an antidote, but also an expert authorized to deal with therapeutic substances. The fact that she implicitly presents herself as such an expert shifts the problem to another level. By challenging the medical authorities, the stepmother is questioning the causal nexus between what the physicians said it would happen and what actually happened. Has the stepson's death been caused only by what the physician said? Because normally drinking cold water does not cause anyone to die. So what the external evidence is that allows us to identify the stepmother's action as direct causa mortis in such a highly abnormal case, where it would be more plausible to think that the stepson died from his illness. This is the stepmother's implicit defense and attempt to escape punishment. This is how she tries to save herself, knowing that the fictitious law, and on another level, the Lex Cornelia, punishes only malice aforethought, not guilt. This is how she responds to her husband, who inferred criminal intent on her part by the instrument used for killing. Built on culpa, her defense could perhaps be construed, in my opinion, as anticipating from a conceptual point of view the juristic elaboration of reckless administration of venena and the punishment extra ordinem of culpable homicide. We are still within the stepmother's ethopoeia and see her asking whether experimenta medicina ignota sunt. A polemic against physicians runs through the stepmother's ethopoeia. The rhetorical question discredits the physician's expert opinion in the sense that physicians are always experimenting and hence perform experiments in a merely corroborative way to support a preconceived idea, or implies that giving cold water was an experiment on her part. Although medical advice could be sought in cases of medical treatment, it alone was not expected, at least in the stepmother's mind, to be taken for granted to determine whether one should pursue the advised treatment. The underlying idea that the decision for medical treatment could be based not only on medical diagnosis, but also on non-medical personal factors may be reasoned, but its validity would not have been self-evident. Hence, the father's earlier criticism for not consulting with him. In any case, the idea that a lay person could employ an ill-advised treatment without taking into account expert advice renders the stepmother an intellectual threat to the medical authorities invoked by the father. And more importantly, such an allegation of incompetence weighing upon the stepmother physician may offer insights into lay perceptions of the physician as someone who could commit murder without being put to death, thereby revealing Roman attitudes about the ambivalent portrayal of physicians in ancient literature and society, and more specifically about the place of experimentation in ancient medicine and the physician's moral duty to engage in such an activity to protect health and enable progress. Supposing that the declamation is incomplete, as it has been proposed, it is fair to imagine that the father's final response would involve an attack about risk in therapeutics, the fact that the stepmother dared a fatal experiment running counter to medical advice makes her an assassin. In this dissimulated opposition to pharmacotherapeutics and scientific experimentation, one could trace the influence of the empirics in their advocacy of experience over experimentation, and also an aversion towards lay people acting as physicians and irresponsibly practicing some form of medical experimentation that involved substances. But returning to the final point in question, which is criminal intent, the stepmother's defense is overall weak. If physicians, Roman physicians, tended to be cautious in employing treatment for which they might incur blame for the death of a person, and if there was a strong prejudice against them, especially in cases of suspected poisoning, the stepmother's rush to novel experimentation without the father's consent can only be explained by her intention to kill her stepson. And despite her efforts to imply so, she did not act as an imprudent lay person, let alone as an incompetent physician. She is simply and plainly an assassin. Conclusion: to the extent that the fictional world envisioned in school forensic declamations can be understood as reflecting context-embedded elements of the Roman legal system and its normative ethics, Pseudo-Quintilian's Declamatio Minor 350 contributes, in my view, to clarifying the cultural background and the argument-based approaches to the way in which the Lex Cornelia de Sicaris et Veneficis was likely to have concretely functioned and evolved in and through court practice. Quintilian does so in an innovative manner by introducing a reflection on the reckless administration of substances that could be deemed socially dangerous. Overall, this is an important intellectual exercise on moral reasoning for the Roman student that negotiates the nature of substances that could qualify as poisons from a medical point of view, as well as of the agent's criminal intent and knowledge of the criminal act at the relevant time. Thank you very much.